they donate which kind of a government they want. Maybe out of 110, maybe kickbacks. I'll address that kickback part also.
Would that be valid if a company were to donate even 100% of its revenue? Is that guided by altruistic motives? We quite see everybody doesn't donate, with as a kickback, not at all.
Therefore, my lord, kindly, my lord,
And
do
we
not
also
see
have
this.
companies. We also have companies. All companies cannot be tarred with the same brush in India. You have corporate sector which has contributed to the productive assets of the nation.
But
So we're
look,
not.
they have
We're not at all saying that our
contributed
corporate
to
sector
the
is therefore
development
tainted.
of the
You
nation.
shouldn't make that assumption.
Well, only a minute, Mr. Sibal. Sibal, sir. No, there was something personal, not. It was not a fun or humor. my lord. Out of concern, I asked something, which I'll right now not share.
That's all right.
We had some concerns. I said, go to my chamber. That's all. Lord, so the idea was that instead of either shell company or paying by cash, let the clean money come into the system. And my lord, clean money has come into the system. Second, whether we like it or not, my lord, industrial houses, commercial houses, corporations, companies, they have, my lord, immensely helped, my lord, in the development of the nation. And now, my lord, as I have shown.
That's what I just said, that we don't
So
start with the
everyone, my
assumption
lord,
that our
does
corporate
not pay
sector
by
is
kickbacks
tainted.
to my lord, believe that they need electoral bonds to be used or any other factor to be used to influence the decision making would be, my lord, shutting an eye on the reality. Without that also, my lord, that can be done. And possibly practically, despite, my lord, this white channel being available, both channels might be used by some companies which are, my lord, not kind of good companies. But good companies, my lord, do decide to donate based upon their experience, whether in this regime of the political government, my investment is safe or not, whether the country is going forward or going backward, whether I am.
All right, Mr. Solicitor, we now understand this.
But
can we do this to sort of to carry the dialogue further? Should we go straight to the scheme? Because we'd like to hear you on the scheme.
Page 25.
Let's have a look at the scheme
Page
so that
25.
your argument on the scheme will be of value to us. This we have now seen that
Because your
you
lordships
have made your
have,
point, no doubt about it.
not kindly, your lordships have the challenge to a provision which gives away or does away with the cap. I have given my answer for your lordships to. I think I am clear.
Yes, of course.
Now, my lord, the scheme. See the definition, my lord. And my lord, please read, my lord, as if it is for a bona fide reason and not to encourage or legitimize kickbacks. Please examine that. There may be 10% out of 100 where kickback is provided. Kickback can be the motive of the donor. Electoral bond means a bond issued in the nature of promissory note, which shall be a bearer banking instrument and shall not carry the name of the buyer or payee. I have already explained why this is, why this confidentiality. So I will not read the second part, the second column is the object behind it. Object I have sufficiently attempted to explain and therefore I will not repeat it. Please see, my lord, authorized bank. This is the entire policy produced, reproduced verbatim. I have not missed anything. So your lordships can read either from the policy or from here, but here it would be more convenient because I have given my object of each clause.
You're right.
But there is no part of the policy is missed, my lord, in reproduction. Authorized bank means the State Bank of India authorized to issue and encash the bonds in the branches specified in Annexure 1 to this notification. My lord, we had options, my lord, of public sector banks and private banks. Obviously, we cannot choose private banks. In public sector banks, the largest bank with largest presence in the country is State Bank of India. Therefore, State Bank of India. there is a specific exclusion of private banks in the FAQs. They don't use private banks for this channel, because let it remain in one particular bank which can be trusted. And your lordships would not, kindly bear with me, not trust institutions. And I'm going to show to your lordships that there is any deviation. If anyone tries to breach into the confidentiality, it leaves its footprints and will not go unpunished. My lord, I, as a law officer, spoke to the chairman of the State Bank of India. And I have his letter signed by him saying three things. A, except the contingency contemplated under section 7(4), that is the court's order, nobody can get. Well, I might even read, my lord, the letter, my lord, so that your lordship conscience is satisfied that even ruling party will not know. But if I can share, it's a 3-paragraph, 1-page letter, my lord, just to satisfy your lordship's conscience that the scheme does not allow or permit even ruling party to know about it, even the government to know about it. The central government as a body, my lord, no, not forget the ruling party in the government, central government would not know. Lord, Lord, I have the hard copy, my lord. I will. Lord, this is a letter addressed to me. Or may I read? In response to the queries of the Solicitor General, we submit our response as under. The State Bank of India has a foolproof mechanism for maintaining complete secrecy of details of purchaser of the electoral bond and also the political party which deposits such electoral bond. This information cannot be shared with anyone, including the central government. In the eventuality contemplated under clause 7(4), there is a scientific system available whereby this confidentiality can be decoded by a process and be placed before the competent authority or court under clause 7(4) of the scheme. It will not be in the interest of the scheme to put it in public. The mechanism which will be used while decoding information for being provided as required under clause 7(4) of the scheme. Now, my lord, the largest public sector bank is before the highest court of the country, signed by the chairman of that bank saying that this cannot be shared even with the central government. And we have a mechanism in place that nobody can breach it.
That's fine.
So, my lord, the point I am respectfully making is that we have to trust institutions that they will go by the law. My lord, if there is any deviation, I have a suggestion, my lord, which I'll make at an appropriate stage when I come to that part of the scheme. Now, my lord, C is issuing branch. Issuing branch means a designated branch of the authorized bank specified in Annexure 1 for issuing electoral bonds. Lord, everywhere it cannot be purchased and everywhere it cannot be deposited. Because, my lord, what happens is, my lord, why this? The donor and donee both must have a designated account in a designated branch. Why? My lord, I'll just very candidly and very bluntly point out, my lord, what can happen. My lord, I purchase a bond of 1 crore of rupees. I'm sorry, my lord, your lordship, sir. I purchase a bond of 1 crore of rupees. I give it to a political party. They don't wish to show it in their return at all. What they can do is, they can go to one small cooperative bank in Trichur or some corner of Gujarat or some corner of Lord Maharashtra, deposit it, withdraw in cash, and nobody would come to know. To avoid this, we have said that every political party will have one designated account. Only there it can be deposited, and that would be in one of the 29 designated branches. And it is so ensured that each branch is there in each state, broadly. Then, my lord, D. Person includes an individual, a Hindu undivided family, a company, a firm, association of persons, or body of individuals, whether incorporated or not, every artificial juridical person not falling within any of the preceding subclauses, and any agency, office, or branch owned or controlled by such person. But petitioners have confined their arguments essentially to companies. But this includes all. And, my lord, there are several donors from experience, my lord, when I discuss, who donate on individual basis. Lord, there are several conventional businesses like transport business, like contractors business, where they are individuals who do the business. They don't form any kind of formal company or Hindu undivided family or a partnership firm. Then third, eligibility for purchase and encashment of electoral bond. The bond under this scheme may be purchased by a person who is a citizen of India or incorporated or established in India. Lord, I am keeping, my lord, FCR apart separately. That's not something which is argued. Your lordships have very consciously, my lord, by judicial order detected. A person being an individual can buy bonds either singly or jointly with other individuals. Only the political parties registered under Section 29A of the Representation of People Act and secured not less than 1% of votes polled in the last general election to the House of People or Legislative Assembly, as the case may be, shall be eligible to receive the bond. The bond shall be encashed by an eligible political party only through a bank account with the authorized bank. There would be a designated account out of these 29 designated branches. But the objection was that why this 1% limit? And there is a simple reason. Earlier, when exemption was given to political parties, there were some mushrooming of political parties, fake parties, just to get exemption. Therefore, 1% presence would mean you are a serious political party, and 1% is not something, unrealistically high. And it can be even in parliamentary election or in any of the assembly elections. So just to, ensure that there are no fake parties which are created to get benefit of this. Then, 4, applicability of know your customer norms. The extant instructions issued by Reserve Bank of India regarding know your customer norms of a bank's customer shall apply for buyers of the bonds. The authorized bank may call for any additional know your customer documents if it is deemed necessary. Now why this? Apart from the obvious reason that there cannot be any anonymous purchase. I cannot go and say that I will not give my name, but give me the electoral bond. There is a list of, my lord, KYC documents. I'll have to give my Aadhaar number. I'll have to give my PAN number. I'll have to give my residential proof. I'll have to give my passport number, if any, etc., so that anyone cannot just walk in and purchase the bond. That is, my lord, the object. My lord, my lord, there is one more reason, my lord. And your lordships, my lord, as the highest court must know about it. My lord, therefore, I am saying, Lord, India is a signatory to one treaty, international treaty, Lord, that is for eradication of money laundering and drug money, under which there is that's Vienna and Palermo, that there are two conventions where there is one financial action task force. It's created under the aegis of the United Nations. That task force has created 40 conditions that every country who is a signatory will have to follow those conditions. Based upon every country's performance or compliance of those 40 conditions, there is a peer review. Other five persons from different countries would come and review our system, whether we are following that or not, and would grade us. We can be in white, what do they call? White list, gray list, black list, which which decides whether in international market like World Bank, Asian Development Bank, India as a nation would get the financial assistance or not. If we are in the gray list, we will not. One of the major condition is that bring your clean money into the system, and one of the mode is to insist for KYC documents. Therefore, my lord, the neighboring country was in the grey list. It managed to come out of it. Otherwise, my lord, it was going into the blacklist. And that also depends, based upon the gradation. Gradation also decides our credit rating at the international stock market, the country's credit rating. Therefore, it's very crucial to follow those 40 principles. Then denomination. The bonds shall be issued in the denomination of 1,000, 10,000, 1 lakh, 10 lakh, and 1 crore. Well, this is for the purpose of administrative simplicity. And my lord, as your lordships, my lord, very rightly, my lord, expressed the concern that somebody can be aggregator. My lord, if I want to donate 50 lakhs, then 50 crores, then I'll have to find out 50 aggregators. Instead, it is easy for me to go and pay cash 50 crores, that this is my contribution. Why should I go to?
No, the party does not get money in white.
The
party wants capital.
Party does not need money in white. Let us be very clear. The government is insisting that every party.
This is not a scheme only for elections. It's not a scheme only for elections.
Correct, Manoj. It's for running the party. It's for running the party. No, I am not feeling shy of saying that, Manoj, because that's the part of the scheme.
It applies to everybody across the board.
Across the board. My learned friend said, ha, as if he trapped me into it. I am saying it consciously. Manoj, what happens is.
Manoj, I am an independent member of parliament. I don't know why you associate me with the party.
Yeah.
History can't
let's not go into it. Let's
victimize me. Don't victimize me by my history.
He's not entitled to get an electoral bond under the scheme. He doesn't have 1% of national or the local vote.
Let's not go into it. A personal thing, I never, Malad, intended. Malad, what happens is, let me clarify that position. This is not for election. Malad, when we talk of election, we think of general parliamentary election. When a political party is running, it contests parliamentary elections, it contests assembly elections, it contests local authorities elections, it has its own campaigns, it has its own rallies, it has its own think tanks. Think tanks are also, every party has think tanks, their salaries, they need some kind of a building in every state. They need offices in every part of the country where the voters would go and seek some minor help, like my name is not entering into the ration card, etc., and some workers of the party, each party, so it's holistic, it's nobody has so far, heard, at least I have not heard that, as my learned friend gave a very fantastic example, that bungalows being built for the leaders. No party, I'm not on one party, has built bungalows for any leader. But they are building offices and other electoral expenses. Now, what comes to the validity of the bond. The bond shall be valid for 15 days from the date of issue.
Nowadays,
Sibal sir.
Just consult, if you're not feeling too well, we can sit in one of our ante rooms and watch it on your iPad. You know, we are now on streaming online. You
My lord,
can just go
I
and,
requested, my lord, Mr. Sibal to sit in my chamber and we have the video
you
hearing.
can ask the
I
registrar.
didn't want to say
At the
that.
time when I have to reply, I should be here, Manoj.
No, you can listen to the arguments.
If you would like to sit in one of our conference rooms, I can ask the registrar to.
Yes,
you
that can be
can-
done. Manoj. I'll sit there. I'll sit
That
there
you
and
can
watch
just-
if your lordship
My
don't.
lord, in the morning, my lord, in fact, I suggested that it's nearer.
Yeah, I can do either.
No, you can
The
go in
registrar
my.
will just escort you, so you can take your iPad. and
Mr.
watch it.
Sibal, well, that's exactly what I told him when I
The
said,
moment he is here, we'll ask him to escort
my
you.
lord, my gesture was in.
No, we realized the moment you said that.
That you go to my chamber, but the video will be on. You can keep the video off and listen to the arguments. And
The work is, of course, part of our duties and daily lives, but you know.
not at the cost of health, but that's what I.
बता दो, पुनीत को बता दो.
No, my lord,
the track, the KYC with regard to anybody who makes donation above 2,000 rupees is also required to be done by the political parties, or is this format prescribed for that?
I'll just ask because in the scheme doesn't provide
No,
for.
this has nothing to do with the scheme.
I'll just, my lord, take instructions, my lord, and. Is for banking channels, yes, even if it is less than 2,000. But political parties can, there is no.
There's no.
The political
No, but
parties.
when you take the name and other details, they don't take any document in support there.
My lord, as a matter of fact,
I'm just asking as a factual.
my lord, practically, my lord, let us
It's
speak.
not possible, it may practice.
Nobody pays, my lord, 1,900 rupees or 19,000 earlier rupees, my lord, nobody comes. If I get as a political party 100 crores, I'll have fictitious names divided into whatever is the amount, and I'll show that so many people, so many thousand people gave me 1,900.
There's no check as far as
There's no
multiple deposits by same person is concerned.
That's so now that incentive is not. But if 1,000 is also electoral bond permitted, if I want to buy electoral bond of 1,000, it is through the KYC channel only. But if I want to go and give 1,000 rupees, which nobody would go and nobody would take, but then there is no KYC. Not anybody can go and take. Then, my lord, validity of bond. The bond shall be valid for 15 days from the date of issue, and no payment shall be made to any payee political party if the bond is deposited after the expiry of the validity period. The bond deposited by any political party to its account shall be credited on the same day. Look, this is one check, my lord. Kindly see, my lord, why this 15 days period. A, it does not become a currency. It does not become like a bearer bond which can be traded. That is number one. Number two, Lord, this eliminates the element of a potential kickback. I'll tell your lordships how. Lord, I keep a electoral bond of say 100 crores with me. I tell a political party which is about to go in election that I have 100 crore. If you form the government and if you give me this contract or whatever is the quid pro quo, this is yours. If 15 days is to be, my lord, mandated, this is not possible. I have to give it to them and take a chance. If there is a quid pro quo. I again say, all do not donate because of quid pro quo, fortunately. But we have that business atmosphere, that business environment.
What was the actual reason for putting this 15-day cap? I mean,
Look, this was the reason. A, it doesn't become a trading currency that I owe 1 crore to my learned senior, my lord, learned attorney. I don't have Lord ready cash, which I can give it, or he doesn't want to accept cash or whatever. I can give him the bond. So bond is not a trading commodity, cannot be traded. Second, as I, my lord, I'll just, my lord, explain in a different way. My lord, let us give a live example so that, my lord, it can be better clarified by me. Madhya Pradesh is going in election. BJP can win, Congress can win, or any other party technically can win. I go to Congress with 100 crores worth of electoral bond. That this bond I have. If you form the government and give me this particular contract after you're forming the government, this will be yours. This would be quid pro quo, which is, my lord, completely minimized if I have to deposit in 15 days only. So I have to give it within 15 days, and they also cannot keep it pending till the government is either formed or not formed. They have to deposit. So I take that risk as a contractor of paying to a party which may or may not form the government. That is why this 15 days. But these are all checks and balances, whichever could be practically thought of, are incorporated. That it is not becoming another problem while we are trying to find a solution. Sometimes the solutions are bigger than problems. So therefore, while the Honorable Finance Minister, the then Finance Minister, says that this may not be a foolproof scheme, but we have tried to make it as transparent as possible. And, my lord, it will be read with 12. If it is not deposited in 15 days, it goes in Prime Minister relief.
that yes.
So money you don't get back. The donor does not get back the money. It is for him to ensure that the party deposits. Otherwise, what happens is he is out of pocket for 1 crore or whatever crore. Party doesn't get it, so he doesn't get, if at all there is any quid pro quo, and his money goes in Prime Minister's relief. Therefore, my lord, he will also have to say that, but you deposit this amount. Otherwise, my money will go to Prime Minister Relief Fund, not for the purpose I am giving you. So this is, my lord, a strict check, which is inbuilt. Yes, my lord.
And you have now seen the scheme. You have explained it.
Only 7, my lord. I have a suggestion. Therefore, my lord. My lord, another thing my learned attorney, my lord, very rightly says that this is not election-related bonds. Your lordships have seen every tranche is 4 times,
Right.
4 quarters of the
January,
account.
April, July, October.
So, my lord, I as a political party get 10 crores. I can't wait till the next election and promise him that if I get elected, I'll deposit and I'll give you something as a quick. If it is a contribution, it is a contribution. Within 15 days, you have to deposit. My lord, 7. My lord, which might, my lord, I'm going to make one suggestion, which might, my lord, perhaps substantially take care of your lordship's very valid concern.
Can you make the suggestion? We can just take it down and then we read it together.
Kindly have a look at, my lord, the 7 first.
Yes.
Procedure for making application for purchase of bonds. Every buyer desire of purchasing bond can apply with a physical or through online application in the format specified in Annexure 2, which provides for KYC, etc. Your lordships are right now not concerned. Every application shall contain particulars. Your lordships can leave it. On receipt of an application, the issuing branch shall issue the requisite bond if all the requirements are fulfilled. Now, 4 is important, where my lord, the Chief Justice had some concern, and my lord Justice Khanna also had some concern. And I'll, my lord, very candidly express that concern and, my lord, satisfy your lordships. 4.
Yes.
The information furnished by the buyer shall be treated confidential by the authorized bank. First part. This is the mandate of the scheme. Correct, my lords?
Yes.
And shall not be disclosed to any authority for any purposes except when demanded by a competent court, to which, my lord, no one can have any objection. We have to trust the court ultimately. Or upon registration of criminal case by any law enforcement agency. My lord, there are two things which may, my lord, perhaps not be acceptable to your lordship's conscience. A, what happens if this confidentiality, which is statutorily built in the scheme, is not adhered to?
Yes.
But your lordships would mark that if I try to breach the confidentiality system, it would lead digital footprints left. It's not, my lord, as if my learned friends were it's not even oversimplification, something less than that. That you can just see in the light and you get the number and you can compare it with the political party. It's not like that. If necessary, my lord, I'll come to that. My lord, what is the system? It leaves its footprints in the digital format which cannot be erased. Please read and kindly see, my lord, the intention of the government and, my lord, the bona fides of the government. Anyone not complying with or committing breach of this confidentiality, your lordships may say, would be criminally liable for criminal breach of trust. Or whichever other provision, my lord, which is applicable. I have not examined, my lord, from IPC point of view.
Yes.
Correct, my lords? So this takes care of one thing, that you have the biggest public sector bank, the assurance of the chairman of biggest public sector bank, with your lordship's direction that any breach will be visited with penal consequences. Now, my lord, second, and that's where my lord Justice Khanna's very valid concern, my lord, was expressed. So far as court is concerned, my lord, I don't think anybody has disputed. My lord, somebody were to go to the court. My lord, for example, just to answer my lord Justice, Chief Justice's query, that there is a quid pro quo. Suppose somebody goes to the court that this gentleman has given money as per his bank statement or as per his account, or this company has given 50 crores to some political party as per his statement. Kindly listen to this. This is interesting, my lord, how the scheme works. That this company has given 50 crores to some political party, that is reflected in their balance sheet, which is to be made public as per the company's law. Immediately thereafter, the one particular government has given him a contract worth 250 crores, and therefore I suspect he has to give reasons. He can't rush the way PIL petitioners are rushing. But he can say that there may be a quid pro quo, and the court is prima facie satisfied that yes, there may be. Let us see whether those 50 crores has gone to the party which is in the government who has given the contract. That is why, under the court's order, it will have to be decoded, which has a very serious and complicated process. It is not easy even under the court's order. Now, the concern of my Lord Justice Khanna, and very right concern, that upon registration of a criminal case by the law enforcing agency, my Lord, the concern would be that you register a criminal case and ask SBI that give me the details. That was, my Lord, the concern. Your lordships would recall in Aadhaar judgment, there was a similar provision. And your lordships have read it down to me to say that when investigating agency wants this, it can get only if there is an order of the court. Kindly put that layer by reading it down.
Yes.
Look, kindly see, my lord, the bona fide is, the purpose is not that the party in power knows what is paid to whom. The purpose is not that this is to be used for the purpose of penal persecution.
Yes.
So, my lord, level playing field, when we talk about the level playing field, my lord, if I have to understand level playing field means every party should get equal political contribution, that can never happen. Mr. Sibal would have 10 matters, somebody would have only one matter. Nobody can argue that there should be level playing field, everyone should have 3 matters. That every political party will have to rise to the level that they get more trust and they get more contribution. But if the level playing field argument is attached to the fact that the party in power comes to know about it, well, this is the way in which it can be taken care of, and both apprehension and the public interest can be balanced. That even party in power will not come to know. Now, my lord, at this stage, my lord, I would like to show how, my lord, this scheme operates to satisfy your lordship's conscience. Because yesterday I found, my lord, your lordship's valid concern that it is possible for the ruling party to know, but rest of the parties would not know. My lord, as I was told by the chairman, that it can't be discussed publicly. Whatever can be discussed publicly, my lord, I have a separate thing. On my request, the officials of the SBI are here. Lord, I would request your lordships, if your lordship would like to know the entire semantics, how this system operates and how there are separate silos which cannot be breached, and you have to go into one system, you have to go into another digital system, you have to go into third digital system, leaving your footprints. If there is a court order also, then your lordship would be satisfied that it's not as if that a finance secretary calls the managing director of SBI कि हर 15 दिन मुझे भेज दो किसने कितनी कौन सी पार्टी को कितने पैसे दिए. It's impossible. It's that foolproof a system. Your lordships can hear them in chamber. But right now, my lord, I may show this, my lord, what is the system to satisfy your lordship's conscience. It's not, my lord, as if that I go and deposit some amount in the bank and tomorrow the senior official of the bank calls the branch manager, what amount Tushar Mehta has deposited. He will just see and say that he has deposited 10,000 rupees. It's not that simple. It cannot be that simple. When we are ensuring confidentiality, and when confidentiality is the heart and soul of the scheme. Please, my lord, allow me to share this, my lord, screen share this. My lord, there are extra copies also. I have emailed also. Okay. But I have not, my lord, I have missed purposefully. I have decided, it's my, my lord, call that I have not said many things which the chairman also rightly feels and I also feel should not be made public. What is, how we maintain secrecy, my lord, can't be a public debate. That's all. Because by definition, it has to be confidential.
So, just so that we have a little bit of an eye on the clock, learned attorney will take about half an hour after you are done.
I think so, my lord. I might be over by 1.
1 o'clock if you 1 o'clock if you finish.
I will.
So learned attorney can then argue between 2 and 2:30.
Correct.
And then we can leave a
Lord,
little time for
I can rest assured, I can, my lord, assure your lordships that every judgment which I have quoted, I'm not going to cite. I would be very naive if I quote judgments which I know your lordships
give
have
us
read.
the citation and the paragraph so that.
I have quoted that.
Oh, I see. In your-
So I'll say that kindly read it. My lord, I'm not going to read except few judgments which I'm unable to resist that.
You may just flag those. That's all for us.
Yes, yes, yes. Lord, this is, my lord, the copy is given.
Leave yourself a little time to deal with the challenges to the amendments to the statutes. Huh?
These are, my lord, the objects.
Right, right. We have now covered the scheme.
No,
I'm just saying that since you have an hour to conclude, give yourself a little time to deal with the challenge to the statutory amendments.
that's what, my lord, my answer is, one line answer. The statutory amendments are to ensure that this scheme can be framed and can be operated. That's the purpose of the amendment. There are no separate objects.
Separate, yeah, that's okay. And you have
They
really
are-
covered the reasonableness aspect as well.
There are corollary
Yes.
to my lord, the scheme. First, it came under the Reserve Bank of India Act that government can formulate the scheme. That is challenged to the Reserve Bank of India Act. My lord, now by itself is not illegal.
Just wanted to ask you this. It may not be very relevant for the, but just to understand the legal framework. Why was it necessary to amend the RBI Act actually to bring in the scheme? I mean, as a
Yes,
matter
yes.
of law, what was the reason?
My lord, that
We just have that. I have, in fact, it opened here at page 31 in
Yes.
your written submission. Section 31 says that no person except the Reserve Bank of India or the central government can issue a bill of exchange, promissory note, or engagement for the payment of money payable to be to bearer on demand.
it would be a bearer bond, my lord, because
But the reason seems to be, and that's RBI's report, that only central government and RBI is permitted under that section. The issuance is being done by SBI now. So
no, that's not the idea.
Yes, so it's somebody else which is being permitted, and that's one of the reasons which the RBI's letter also, which I think Mr. Bhushan showed to you.
My lord, there is no, nothing turns on the, and you will not succeed or lose on this. But my lord, the purpose was,
31 may have. 31.
please see, my lord, one, this was to make an exception to one.
There's an authority or the legal
There
power
is
to
a
issue this.
statutory backing to
Statutory.
the scheme. That's
Want to be confronted with a legal
That is
challenge.
a purely executive act. minus,
yes, otherwise it would have been challenged as an
the
executive act.
legislative backing.
It could have been said that it's a bearer bond, only the RBI can issue, etc., etc. And therefore, my lord, with a view to empower the central government to come out with this policy.
And it would otherwise fall within the broad definition of a bill of exchange.
Exactly. Or a bearer, my lord, instrument. They say payment of money payable to bearer on demand to borrow.
Or engagement for the payment of money payable to bearer on demand. Engagement is very broad.
And one,
Therefore, that
my lord,
subsection
subsection
three-
1, first line.
Yes.
First line, subsection 1, no person in India other than the bank, that is RBI, or as expressly authorized by this act. So this is the authority given to the central government. That's all, but to give a statutory backing so that it doesn't remain an administrative instrument.
All right. Now what next, Mr. Solicitor?
Yes, my lord. My lord, now what I'm reading is on the screen, my lord. I have shared, my lord. Lord, your lordships may skip 1 Roman 1 or 1 Roman 2.
Read this out.
Or 1 and 2, Roman 1 and 2. I've said, nothing to hide, my lord. I've said that the chairman has, my lord, one should trust the system, etc. my lord. Third, without elaborating, however, a brief description of the system can be provided to the court to satisfy the court's conscience that it is impossible for anyone, including the incumbent government, to breach this system without A, the contingency contemplated under clause 7.4, or B, without leaving a digital footprint and trail if someone tries to breach into the system over and beyond the mandate of clause 7.4. The process for providing donations through electoral bond has two separate compartments, and they are issuance of bond and redemption of bond. Correct, my lord? Your lordship knows. I leave it at 3. In order to maintain confidentiality of the process, the data that is populated at both ends is recorded in a limited manner and not populated in the central databases. It doesn't contain the name of the donor. My lord, I can purchase it from Assam, Guwahati, because that is one of the SBI branches, and pay in Delhi to Indian National Congress or Bharatiya Janata Party because their office is situated here. They can have their authorized account practically, generally in Delhi, but anywhere in the country. And I can purchase it from Delhi and pay to Trinamool Congress in Calcutta. They would have their account in Calcutta. Now, 4, separate storage and separate collection of data ensures that there are no direct linkages maintained in the database between the donor details with donee details. 5, the register which is maintained at the designated branch, please mark this, which issues the bond does not maintain the register with names of the purchaser or the donor. So if I go and buy a bond worth 1 crore, the register would only say one bond issued, 1 crore rupees. My name will not come. The only person, my lord, I must, my lord, tell your lordships, which would temporarily come to know would be the cashier, my lord, when I go with my KYC documents. Because,
the issuing bank.
yes, the one person.
11.1 says, all payments for the issuance of the bond shall be accepted in Indian rupees through demand draft or check or through electronic clearing system or direct debit to the buyer's account.
Yes. So it will
payment
have
is
to
made
be
through
through
check or
banking
draft
channel.
shall
No,
be
the
drawn in
purpose
favor
is
of the
this.
issuing bank, and therefore the issuing bank has all the data.
No, it would come, my lord. Therefore, it would come. The only person who would first know my name and is the person to whom I give KYC. Then KYC is sealed cover is maintained elsewhere. But it comes. The details of donor, i.e. the KYC details, are put in a sealed at the end of each tranche, because within 15 days, many people purchases many multiple bonds. But I may purchase 10 bonds worth 10 lakhs of rupees. Tranches by the designated branch and sent in a sealed covered form to the SBI main branch, Mumbai main branch, where it remains sealed till the contingency under clause 7(4) arises. So Guwahati, where purchases are made, or Trivandrum, where purchases are made, will send it in a sealed form to Bombay. So far as the redemption of these bonds by the political parties is concerned, each party can deposit such bond only in their designated account. In account details of the political party also, only the amount of the bond will be reflected, as the bond does not contain the name of either purchaser, donor, or the political party. The political parties would have one designated account in one branch out of the designated branches of SBI, in which only the redemption of electoral bond is permissible. So bond may have been purchased, my lord, from Chennai, but will be redeemed or can be redeemed in Calcutta. However, the political party can present the bond for redemption in any of the designated branches, which will credit the amount only in the main designated branch. They can go to Jaipur and say that this is my bond. The money would be transferred without anybody's name to the designated account wherever it is maintained, one designated account. At the time of redemption, the original bond, the pay-in slip would be stored, storage in a sealed cover and sent to SBI Mumbai main branch. Both the sealed covers cannot be opened either together or at different times, except under the contingency under clause 7(4) arises. In the event of contingency under clause 7(4) arising, it would be very difficult to trace out that. Even after that, my lord, kindly see this. It's not as if we open the cover and match it. Trace out the details of the purchaser of the bond, as such purchaser may have purchased several bonds from several designated branches in different tranches. In other words, several sealed covers may have to be opened and examined. 2. So far as details of redemption details are concerned, they are stored in the Global Information Technology Center of SBI, which stores the data in a digital format. in case the link between the donee and the donor is required to be established in terms of clause 7.4, it would require a detailed and in-depth tracing out of information from two different information silos of donors and donees. The said exercise is not automated and cannot be carried out in a linear fashion and requires a scanning of different databases which are designed without maintaining interlinkages. Therefore, the process of issuance and redemption of electoral bond and data generated therewith is not maintained in a central database, and the data sheets are not populated and tallied at one end. There exists no direct linkages, and completely separate information silos are stored under separate heads with separate departments. So I'll have to ask several people to collude with me if I want to get the information. Because, Lord, I have not given that, but this center, Lord, Global Information Technology Center also, as I was, Lord, explained, I was also not explained in detail, and nor did I insist. But they also have 3-4 layers. It goes, the request with the court order goes to one, he will open, then it goes at a second layer, then he opens, and everything is digitized, leaving the footprints. And therefore, my lord, to satisfy your lordship's conscience, I say that please criminalize if there is anybody who breaches this system.
Yes.
Yes. Now, my lord, I'll come to, my lord. Please come to page 36 of my written submissions. Rather, my lord, I would, my lord, at page 37, my lord, I have quoted Puttuswamy. And my lord, I'll abide by the time, my lord, your lordships have indicated. But your lordships would, my lord, bear with me. I have not repeated, my lord, except
No, not at all.
Lord, I'm not reading this Puttuswamy, my lord. Your lordships, all of my lords have read and read it. But the purpose, I'll say, Lord, your lordships have devised this concept of informational privacy. Lord, your lordships were examining two competing interests, namely, one, right to know, and second, right to have informational privacy. And your lordships have accepted information privacy to be a fundamental right. If, my lord, I am the person donating, and if your lordship's conscience is satisfied that system is in public interest, your lordships can accept my right to informational privacy as against general right to know. And why, my lord, I say this? If there is a genuine public interest in the disclosure, you go to the court, you have 7-4 remedy. But merely for your curiosity, you cannot invade somebody's privacy if that privacy ultimately serves larger public interests. Lord, that's the submission which I have made. My lord, I have quoted the relevant paragraph. I'm not, my lord, reading it. Your lordships are aware. Lord, please come
Just
to.
one minute.
You are saying that you are into come to page, I'm sorry,
Yes.
page 39. I'm just skipping through, my lord, rest.
Yes.
My lord, not that I'm giving up, my lord, maybe treated as read.
Yes.
Para 95. In the matter of Puttaswamy, this honorable Justice, it should be Justice Puttaswamy, this honorable court discussed the validity of section 33 of the Aadhaar Act, which provided for disclosure of information including identity. I'm sorry. I was on 95 reading Puttaswamy, second para, 95 second para. It is submitted that while upholding section 33, this honorable court, however, added a layer of safeguard as per which such information may be shared only upon an order being passed by the judge of a high court. Now, your lordships respected the privacy, but in public interest, if lordship says that if it is required, then of course with the order of the high court. So it's not, my lord, as if it's an afterthought which I'm suggesting to your lordships. It's already there in my written submissions, which shows, my lord, that the intention is not that there is no level playing field. Government, whichever is the party in power, knows about it, and the rest of them do not know. Nobody should know. That incentivizes clean money coming into the system. Then your lordships, my lord, kindly skip the rest and, my lord, come to, my lord, I have quoted, my lord, FAQs which are relevant, my lord, but broadly I have indicated, my lord, what are those, my lord, FAQs. Please come to, my lord, page 46, my lord, 46. This I have already argued. I will not, my lord, bother your lordships. Please come to page 48. My lord, here, my lord, I would respectfully seek permission to read only few paragraphs of the judgment, my lord, because your lordships had a valid concern that in some cases it can be quid pro quo, in some cases it can be misused also. My lord,
Yes.
nobody says that it cannot be. Any system can be misused. There can never be a system which is so foolproof which can never be misused.
You are reading the Shirur Mutt case?
Yes, my lord. Lakshmindra Tirth, my lord, the Shirur Mutt, my lord. Kindly see the last 3 lines which are bold and highlighted, my lord. For your lordship's convenience, my lord, I have done this. I don't wish to read the whole. The saving provision contained in section 91 of the Act makes the position quite clear. An apprehension that powers conferred by this section may be abused in individual cases does not make the provision itself bad or invalid in law. Now, this is, your lordships are aware, my lord, 7 judges case. 7 judges judge. It can, my lord, in Indian ingenuity is, my lord, popular around the globe. And general human ingenuity, my lord, everywhere this is happening. Then, my lord, please see 117. Similarly, in collector of customs versus so-and-so, this court observed the possibility of abuse of a statute otherwise valid does not import to it an event of invalidity. Further, in state of Rajasthan, it was said that it must be remembered. Well, these are very well put, therefore I am tempted to read. It must be remembered that merely because power may sometimes be abused, it is no ground for denying the exercise of power. The wisdom of man has not yet been able to conceive of a government with power sufficient to answer all its legitimate needs and at the same time incapable of mischief. No, there can never be a system. We have started, we have begun, and as I pointed out, the beginning is giving us fruits. Digitized money, my lord, is bringing clean money into the system. I have given the figures, my lord, of payment made by digital mode. Then, my lord, Keshavanand Bharti, in exercising the power of judicial review, the courts cannot be oblivious of practical needs of the government. The door has to be left open for trial and error. Constitutional law, like other mortal contrivances, has to take some chances. Opportunity must be allowed for vindicating reasonable belief by experience. Look, the government, which consists of all politicians, the parliament consisting of all people in politics, my lord, they discussed this threadbare and found that there may be some lacunas in the system, but this is under the circumstances the best system. My lord, that trial and error, my lord, the government is entitled to. My lord, then, my lord, I am not reading Mafatlal, but please, my lord, come to, my lord, I am not reading A.K. Roy also, please treat it as read. Please come to PUCL. Lord, PUCL also, my lord, is on the same lines, my lord, therefore there is no point in duplicating. My lord. Then, my lord, I have pointed out right, my lord, legitimate state interest. But your lordships would always balance. I have argued this, my lord, I will not take your lordship's time further. But the legitimate state interest is linked to public interest. So you have the right to information, no denial, but you have the information which company purchased how many bonds, and you have the information in public domain which party got how many electoral bonds. If anything beyond that is encouraging cash economy to enhance, that your lordships can balance, and that would be in the legitimate state's interest. That public interest would be of paramount consideration when your lordships examine this, my lord. Lord, please see para 130. It is submitted that specific judgment in PUCL and SO, my lord, which were referred to by them, sought disclosure of information which was already in the knowledge and possession of the state authorities. When they say that you declare what is your property, you declare what are the criminal proceedings, these are all in public domain. At once platform you declare, but here you are trying to lift the veil of confidentiality, which is by design made a part of the very system and which is the pivotal part of that system. And even the government doesn't know it. So, my lord, right to information cannot be claimed from me. Now, your lordships may, my lord, kindly go to Lord Lord, page 60, Lord, one passage from Puttaswamy. This is the majority view, my lord. Of course, my lord, all views are concurring except on the ground of, except the question of money bill. Privacy, your lordship gets that? Privacy and proportionality are two interlocking themes that recur consistently in the above judgments. Privacy, also construed as informational self-determination, is a fundamental value. There is a consistent emphasis on the impact on personal dignity if private information is widely available and individuals are not able to decide upon its disclosure and use. This right of controlling the extent of the availability and use of one personal data is seen as a building block of data protection, especially in an environment where the state of technology facilitates ease of collection, analysis, and dissemination of information. Then your lordships may, my lord, kindly see how, my lord, the judgments cited are different. My lord, I have already said.
Yes.
My lord, level playing field, my lord, I have dealt with at page 64. But, my lord, I have already, my lord, orally made submissions before your lordships, my lord. But kindly see, my lord, 151, para 151 at page 65. I have already marked, my lord, which portion I'll skip and which portion I think I must assist your lordship with. 151. The petitioner claims that there is an incumbent bias as a large amount of money go to the ruling party. It is submitted that whether such an incumbent bias exists, and if it does, what its extent would be is a question wholly irrelevant to determining the constitutionality of the scheme. And, my lord, I have already said that that has been the trend. The ruling party gets maximum because the ruling party has the confidence of the maximum people. Now, my lord, page 65 bottom. My lord, I have said that secrecy per se is not alien concept in even electoral issues. Secrecy of ballot.
That's something separate. In the uneven level paying field, you've referred to fairness of elections. That issue is not been addressed.
Correct.
Has that issue with regard to fairness in elections been, or because of the mismatch between the money power, has that been addressed here? Because that may be a larger picture, not specific, like alone to.
I'll just, my lord, again, my lord, try and attempt to point
No,
out.
you've argued that because of ruling party has always been getting substantially more donations.
Not average Indian voter, be it corporate or an illiterate voter. My lord, we have to accept this fact. And we should be proud of that fact. He is a very intelligent decision maker. A ruling party in 2013, though ruling party may not get maximum my lord, political contribution, because the voter knows that in 2014, the wind is somewhere else. We have to trust his discretion. So ruling party is not getting maximum because of the scheme. That's my submission. My lord,
According to even otherwise, the ruling party would get.
always. Lord, even before this scheme, I have shown from 2005 to 2014, whoever was ruling party, Lord, BJD is a ruling party in one state of Odisha. They have maximum, Lord, political contribution. That's the trend. That's how the people of India contribute. It's not as if because of the scheme, the ruling party is getting any benefit and there is no level playing field.
Yes.
My lord, I have analyzed, my lord, in secret ballot, that secrecy per se is not antithetical to free and fair elections. Sometimes it enhances free and fair elections. Like, my lord, in my respectful submission, the present case. Lord, kindly come to, my lord, page 70, para 165. Where I have, my lord, attempted to address how, my lord, this scheme accelerates or enhances free and fair election, my lord. It is submitted that your lordships have not para 165, my Lord Justice Padiwala.
Yes.
It is submitted that a conjoint reading of the principles of secret ballot and the right to privacy under Article 21 clearly postulates that there exists a claim on part of the donors to make donations without fear of reprisal. It is submitted that such right would obviously not be absolute and would have to be counterbalanced with public interest and concept of free and fair elections, and further optimized with policy interest of bringing the first step of shift from cash to banking channel in political donations. It is submitted that the balancing element in the present policy is clause 7(4) of the electoral bond scheme clearly provides for disclosure in case of appropriate proceedings before the competent court or criminal proceedings. Lord, then I'll not, Lord, bother your lordships further. Lord, then kindly come to page 73. Lord, financial policy and limits of judicial review. Lord, I am not going to read the whole. I'll just read the highlighted part because that would, my Lord, in the facts of the case, be very, very relevant and direct for assisting your lordships. But first is Rustam Kawasji Cooper, your lordships, Lord, know the judgment. Lord, it's a bank nationalization case.
Then Garg is the bearer bonds.
Yes, my Lord, 63. My Lord, would your lordships like me to skip, my Lord, to Kawasji Cooper, my Lord?
Absolutely. You can just show us the title of the
Yes.
case and then we'll
Yes,
we'll
yes.
read it now.
Then, my Lord, in R.K. Garg, I would like to read, my Lord, few paragraphs which are not quoted. Kindly go to, my Lord, page 2175. I'm sorry, my Lord, there is a mistake in volume 2, 2184, my Lord. Allow me to read, my Lord, only few paragraphs.
Same volume.
Volume 2, my Lord, main volume. 2184.
Yes.
Lord, please read
To
para
what?
16 and 17, my Lord, at page 2194, my Lord. Para 16. My Lord, here also it was concerned with the black money part. Therefore, my Lord, I am tempted to read 16. Your Lordship gets, my Lord, page 1924, my Lord. 2194, sorry. 2194. It was then urged, your Lordship gets, my Lord.
Yeah.
It was then urged on behalf of the petitioners that section 4, clause C operates only in relation to a period.
That is,
I'm sorry, para 16.
that's 2203. 2203.
I'm sorry. Your Lordship,
Double two zero.
I'm giving wrong pagination because there are two paginations. 2203.
It's a PDF.
My apologies, I stand corrected. I'm obliged to my Lord Justice Padiwala. It was then urged on behalf of the petitioners that my Lord Justice Gawai got that section 4, clause C operates only in relation to a period before the date of maturity of special bearer bonds, and after the date of maturity, the holder of special bearer bonds can sell such bonds and without running any risk disclose the consideration received by him as his white money, because section 4, clause C being out of the way, he can account for the possession of such money by showing that he has received it as a consideration for sale of special bearer bonds. And so far as the purchaser is concerned, if he has paid the consideration out of his black money, he can claim the immunity granted under clause 3. Thus, the black money of the seller, which had been converted into white on his subscribing to or otherwise acquiring special bearer bonds, would remain white, and in addition, the black money of the purchaser would also be converted into white by reason of his purchase of special bearer bonds. This argument plausible though it may seem, is in our opinion fallacious and cannot be sustained. It is highly debatable issue whether, under the provisions of the Act, special bearer bonds are at all intended to be transferable after the date of maturity. Here, my lord, 15 days. Here, their maturity was long period. For the postulate of the legislation clearly seems to be that on the date of maturity, the special bearer bond will be encashed. It is indeed difficult to believe that anyone holding special bearer bonds would keep them uncashed without earning any interest from and after the date of maturity, when they can be immediately encashed and the amount received can be invested yielding interest ranging between 18% to 40%. Moreover, special bearer bonds would cease to be exempt from wealth tax from and after the date of maturity, and they would therefore be includable in the net wealth. My lord, last line of this paragraph, my lord. But the law cannot be condemned as invalid on the ground that after a period of 10 years, it may lend itself to some possible abuse. Lord, please come to para 19. The argument that black money would be promoted is dealt with, my lord. Lord, please read, my lord, para 19, my lord. It's a long para. I don't propose, my lord, your lordship's time. But it's a similar argument that you are encouraging black economy. The court, my lord, analyzed the entire scheme and said that no, it brings the clean money into the system. Now, my lord, coming back to my written submissions, my lord. Lord, please come to para 78. My lords are aware, but I am always tempted, my lord, to show these judgments, my lord. The Lochner era, my lord, which is known as Lochner era, where the Honorable American Supreme Court was having 7 honorable judges, and whenever there was a economic policy change by the president, it used to be struck down with the majority of 4 versus 1. And popularly, the 4 were known as 4 horsemen, and less known fact is 3 were known as 3 musketeers. That in America this is possible, but be that as it may. No, I'm sorry, 9, but one was being convinced by Justice McReynolds. It is believed that he used to convince. But let's not go into it. Lord, this is Lochner versus New York, ultimately overruled. But my lord, your lordships would recall, Lochner versus overruled starts with a dissent by Lord Justice Brandis.
Justice Holmes as well.
First by Holmes, thereafter Justice Brandis, and thereafter that popular article written by Justice Brandis on privacy in Harvard Law Review. And eventually, my lord, this was the Lochner was, my lord, declared, my lord, not to be a good law, my lord. That also I have, my lord.
All right, we can skip.
But, my lord, it says the government or the legislature, not the government, the legislature has a right of trial and error. No, this is accepted by our court recently, my lord, reasonably recently, when IBC was challenged. But there were several issues in IBC. There were several lacunas pointed out in IBC. But the court said that free play in the joints will have to be given. Even trial and error, unless it is so abhorrently or atrociously arbitrary, that it can never satisfy our conscience, the court would defer to the wisdom of the legislative action.
Even in demonetization, we are also.
I have, my lord, relied upon that, my lords. Please see, my lord, at, where is the judgment? I've just, my lord, we have quoted that judgment, my lord, your lordship's judgment in demonetization. I'll just, my lord, give that site. Well, but the pagination, Lord, I have not marked, but I'm relying upon that.
Vivek Narayan Sharma.
Pardon, Lord?
Vivek Narayan Sharma.
Vivek Narayan Sharma, my lord. No, page 76, my lord, I'm sorry. Page 76, my lord. Lord, it is page 76, my lord. Vivek Narayan Sharma versus Union of India. The lordships would find it at it's 2023 SCC online, page 1, where my lord also accepted, my lord, this proposition that government can have trial and error unless it is ill-intended, so atrociously arbitrary that it shakes your lordship's conscience, or it doesn't achieve the object it seeks to be achieved, or it is for a different object. Lord, suppose the object would have been that the government of the day, the ruling party, would like to know who paid what to whom. Lord, I have therefore, my lord, satisfied your lordships that please criminalize if there is any breach of confidentiality.
Anything else now, Mr.
Lord, your lords, my lord, one of the questions, my lord, only 5 minutes, my lord, was what happened after the scheme was introduced? What is the trend, my lord? My lord, that we have given, my lord, in document number 2A, which, my lord, we highlighted yesterday.
Full compilation of documents.
It's pre-demonetization situation. इसमें देखेंगे voluntary.
My lord, these are figures, and my learned colleague, my lord, has examined these figures. If your lordships can give him 5 minutes to explain what is post-scheme situation, my lords.
Okay.
My lord, that he would be able to do it better, my lord. I'm never good at figures, and my lord.
2A, no?
It is the compilation that is on the screen right now.
Yes.
If my lords would come to PDF page 8 of that compilation, it would show the party-wise income from unknown sources. This is a report by the ADR itself for financial year 17-18. So this is the pre-electoral bonds scenario. In the first table, on the left-hand side column is the name of the political parties. The second column
What page is that?
is page number 6 at the top, but I believe the PDF page would be page 8.
It's page 6 only. 6.
At the top right-hand side, the page numbering is page number 6.
Volume 2A, right? Compilation documents?
Yes,
Please, ma'am.
page 8.
Yes.
Please, Malad. So Annexure 1, party-wise income from unknown sources, financial year 17-18. The first table has on the left-hand side column the name of the political parties. The second column, now this is the pre-electoral bond scenario because 17-18. Second column has the voluntary contributions below 20,000. I believe the Solicitor General has already explained that how this below 20,000 rupees mechanism was previously a sort of a loophole where contributions could come in without there being any identification. So this shows that how the first party has received about 342 crores in this financial year.
Yeah.
The third political party has received about 36 crores in this financial year, and the numbers go on. In the second annexure, my lords, if my lords sees the third political party, the total income from unknown sources is 39 crores. That contributes to about 37% of the total income. Now, my lords will see a trend which starts from 2018 onwards, that these contributions below 20,000, which if, for the lack of a better word, I can term as sort of slightly dubious contributions, have gone down. And simultaneously, the contributions by the electoral bonds have gone up.
2018, there was amendment.
Please, my lord, 2018, the bonds come in.
1 minute, please. Bonds is one thing, but the cash amount which would be deposited had come down to 2,000 rupees.
My lords,
Is
I
that
believe
correct?
No, my lords, the 29C amendment keeps it still at 20,000.
29C amendment, but cash deposits were restricted to 2,000 rupees. Is it correct?
No, my lords, the declaration requirement is in 29C itself, so that amount remains 20,000.
If it is.
So still till date, less than 20,000 rupees can be deposited without it.
Till 20,000, above 2,000, you had to declare your identity?
About 20,000.
Oh, that was retained, but
That-
cash deposits were restricted to 2,000 after the amendment in 2017. When was the amendment with regard to 2,000 rupees?
No, my lords, there is no specific amendment with regard to 2,000 rupees.
There is no specific
Yes,
amendment.
The amendment on 2000 is in section 13A of the Income Tax
Income
Act.
Tax
What it does is that up to above 2000, if you pay by non-cash means, then you won't get the exemption under 13A of the Income Tax
It has
Act.
nothing to
But
do
the
with the
disclosure for 29C remains 20,000. That's right.
That 29C
Remains as it is to that extent. My lords, the next year, that is
No, but
2018,
that
and
may be reflected because of the amendment in the Income Tax Act.
my lords, they may not want to take the exemption also.
No, nobody. I'm yet to see a political party which will say, so once the restriction under the Income Tax Act 13A is made 2,000, the immediate impact thereof is that the figures which will be disclosed will, below 20,000 will come down.
As at the same time, my lords, because there is another mechanism of electoral bonds, that figure has gone up.
Then show us how many deposits were made through electoral bonds of less than 20,000.
My lords, may come to page number 13. There is something.
If that is so, then it will be reflected in deposits of less than 20,000.
There is something else also that comes out from it. The political party that has taken a principled stand of not accepting electoral bonds is still accepting those less than 20,000 rupees voluntary contributions. My lord, may come to page number 13,
That
which is
we
the
saw,
physical
that the
page number.
CPM is
Please, Manoj.
accepting. Yes.
Page number 13, it may be page number 15 in the PDF.
Do we have the breakup of the bonds less than 20,000 and above 20,000? No.
My lords, I don't think so.
Because
That
all
breakup-
are, because 1000 is the smallest denomination.
I'm aware of.
Because all of them are without any disclosure
Any
requirement. So that works across the bar for the electoral bonds.
Anything else?
My lords, this is the point. If my lords wishes, I can take my lords through
No,
the
we've seen
number.
that, page 13.
The numbers of electoral bonds will increase. The numbers of voluntary contributions less than 20,000, which are the dubious transactions, will decrease. The only political party for which it has not decreased is the political party that has taken the stand that it will not take the electoral bonds. So obviously that is a political party that is continuing in the older regime.
What is the ratio of the increase in non-bond deposits?
Well,
to
as the
cash?
non-bond deposits have
Or
gone
to-
down.
No, non-bond deposits. If we exclude the bank transactions, what is the ratio in that?
Well, as the bank transactions have remained the same. If my lords comes to page number 13, and if I would show the latest
Non-electoral, not bank transaction.
non-electoral bond transaction.
So you can pay by check also.
Correct.
My lords may see the latest numbers at page number 40. It would show that the first party has received about, page number 40 would be 40.
This is the ADR report.
One chart and give it. What we can do is, by tomorrow, not for arguments, we can compile this, we understand.
I do not, note of 2 pages or so.
Not a note.
Just a
and the
compilation.
chart.
Correct.
A
A
chart.
chart actually, a tabulation you can give us.
Yes, that
All
will
right.
be.
Thank you. Where is Mr. Amit Sharma?
He's maintaining his confidentiality. It's on the lighter side.
Well, we can start with the learned attorney, then we can hear Mr. Amit Sharma at the end.
Yes. Easy.
Mr. Attorney, then?
Election. He's not there.
He's not here. Please, your lordships. One is conscious.
Yes, Mr.
When the global canvas on election funding, party funding, campaign funding is like a kaleidoscope. I mean, it presents very interesting items, experiments made, and just as a learned solicitor were talking about experimentation. And he has referred to one of the most oft-quoted judgments in US, the New York Ice Company versus Liebman. Experimentations in, economics and related branches to stay experimentation. The court looked at it with a test. So if you look at all these experiments and how they have either invited a wide range of concerns. So I would address your lordships on 3 or 4 important aspects of the constitutional issues raised in this case. Before I do that, a very broad brush has been stated in this case. It is said that this scheme violates Article 14, 19, 21, and also undermines the basic structure of the Constitution. I think we need to take stock of this kind of propositions very closely. Alongside, it also said, well, here is a manifest arbitrary, and therefore Article 14 is attracted. I suppose that we must pay very close attention to an argument because a constitution bench, in terms of Article 145, looks at substantial issues of interpretation of provisions of the Constitution. Except when a reference is made on a difference between different benches. So the substantial questions of interpretation of the Constitution, there has to be something very precise, direct, and not too overbroad statements, which may resemble a political debate. I understand that good part of the arguments made come closer to a political debate rather than precise statement of infringement of any particular constitutional right. Why I say that is placing reliance on 2 judgments of your lordships in the Association of Democratic Reforms and the PCL case that for the purpose of expressing your choice of a candidate, and you need to know the criminal antecedents of a candidate, a specific issue on hand, and a concrete right to be exercised, the choice of a candidate. So when you have a right to know under that, you are not asking the court to declare that in Article 19(1)(g), the citizen should have a general right to have a knowledge about everything and anything in relation to the affairs of the community. You have a task on hand, namely the choice of a candidate. So therefore, you need to know something about the candidate. Therefore, it follows that you must have information relevant for informing you as to how you'll exercise your choice. Therefore, the information issue will always be related to an expression with reference to a particular issue on hand. If you may put it like this, information relevant for determination of an issue, can be a freedom of expression. And that if there is a denial of that acquaintance, then we say there is an interference with the freedom of expression. So somebody calls it mutilation of the thinking process if the information is not available. So we talk about an issue on hand, and a denial of acquaintance of information forbids your ability to formulate an opinion and to reach a choice. So this scheme on hand is not concerned with political contributions per se. That's why I think the court would not get into the larger questions of where should political contributions come from? With what interest do they come from? And to what extent interest can be regulated? All those issues, I think, are completely alien to the scope of the inquiry in this case. That's why even if lots are invited to say the level playing field, it's only marginally relevant to where one is looking at the effect of the scheme. Otherwise, those concerns, as I said, are completely alien to the narrow issue which is presented for consideration before your lordships. It happens in the generality of debates on election funding or political funding that one common starting point is that electoral reform is a claim that current systems somehow adulterates the outcomes that a purer system would produce. So we are not entering into the debate at all. Whether do we have a purer system and an adulterating system, how do you weigh them? Several imponderables would come into this question, both political, social, and economic. Therefore, that question not being relevant for consideration by the court. I'll read a very interesting statement made, not directly connected to this, but when the court is being asked to get into an arena of concerns, thoughts, and matters, and the court is asked to say, look, step in and give something better. So these words by a famous economist, John Maynard Keynes, way back in 1933. I'll just give it to you, Lord, after I finish reading this. Because when the community or even an individual is confronted with difficult choices, the question is in place of what prevails now, and if an alternative was to come in, I'm not very clear about that alternative. I am perplexed. So he makes this very interesting statement. The decadent international, we are talking about capitalist power. Of course, capitalist power. But that capital today remains the lifeline of the nation. He says this, the decadent international but individualistic capitalism in the hands of which we found ourselves after the First World War is not a success. It is not intelligent, it is not beautiful, it is not just, it is not virtuous, and it doesn't deliver the goods. In short, we dislike it, and we are beginning to despise it. But when you wonder what to put in its place, you are extremely perplexed. So these are very important words when any alternative system is sought to be put in place. These questions have to be asked. So when we talk of the scheme being put to test and, let's say, undermining a basic structure doctrine, as Mr. Prashant Bhushan has put in his written submission, I want to deal with some of the issues so that straying away from the question for consideration and to sometimes draw a very broad statement about basic structure can become problematic. It can become too doctrinaire also. So I suppose the court it need not be called upon to enter into those questions at all here. There's one very inviting thought process that comes to all of us is that we tend to say basic structure doctrine is undermined or is in a way in peril. We tend to lose track of the features of the Constitution which are consolidated in the basic structure. There could be an individual picture which can be undermined or in breach. So it is the architecture of the Constitution which is brought in and say basic structure undermined. We have to give very close attention to whether that can ever happen at all in the way it is stated. I wanted to share these broad statements and a few more propositions before I take your lordships through. Just digressing here for a minute. We talked yesterday about free and fair elections and the level playing field, even though I said they're not relevant at all. I asked myself a question: if the information which now becomes coded under the scheme, coded in more than one way, is to be disclosed, and all citizens have a right to access to this information. What is that end which I will put to use by way of accessing this information? General political debate, or determining which party will do better, or we will talk about the quid pro quo after the quid pro quo event has occurred. So therefore, I'm asking myself the question as to for what end and for what concrete purpose is access to information, the information, if disclosed, would become relevant.
Come back after lunch.